Okay, welcome, ladies and gentlemen of the jury. My name is Judge Martin Hoffman. I'm the judge here of the 68th District Court. You are now about to participate in something that's historic here in Dallas County. This is the first remote jury trial in the history of Dallas County. It's also the first jury trial that's been attempted since we went into pandemic among any of the 60 state and county courts here in Dallas County. You'll see with me Judge Purdy. Judge Purdy, if you can go ahead and wave to everyone. She's going to be assisting me here today. She is the associate judge here among the civil district courts, and she's also been elected to be the judge of the 95th Civil District Court once we start up on January 1st. So thank you, Judge Purdy, for being here and assisting us. So first off, I want to talk to you a little bit about why this case and what we're doing here is so important. How many people here can guess how many countries even allow jury trials in civil cases? Who wants to guess? Raise your little number. Raise your hand. We have a teacher here. Why don't we let the teacher guess? You know who I'm talking about?
One.
Well, that's a very good guess. There's only 2 countries in the entire world that even allow jury trials in civil cases. And so if you think about it, this is something that's in the United States Constitution as the 7th Amendment. It's in our Bill of Rights. It's in the Texas Constitution. This is fundamental to what we are as Americans. And the fact that we have not been able to conduct jury trials for the last 8 months until now is something that's undermining all of our rights and constitutional rights as citizens of the United States. By going through this process, you're doing something that's extremely important, and any jury trial is extremely important, but what you're doing now is extremely important, because if this works and we're able to do this jury trial and see it through to the end, we are going to be restarting the wheels of justice that have been stopped for the last 8 months. And I will tell you this, you may ask yourself, well, why are we doing this virtually? Well, there was recently a trial up in Sherman where, and juror number 25, I need you to have your video on at all times. I'm so sorry. There was a trial up in Sherman recently where they tried to do it live and 11 people got COVID. And so the judges here in Dallas County have decided that this is too dangerous for us to try to do live jury trials. So our only option is to try to do something like this. And so this is an historic moment. This will only be the 3rd trial ever attempted virtually in the entire state of Texas. And so what you're doing here is extremely important and it's fundamental to us as Americans. And you may say, well, aren't we about to have a vaccine? Well, maybe, maybe not. But the first thing that was closed down when we went into pandemic, can anyone guess what the first thing that was closed down? Before bars, before anything else, what was the first thing closed down? I'll pick on the teacher again. What do you think the first thing that was closed down?
Trials. Court.
Jury trials, exactly. Jury trials were the very first thing that was closed down. And you want to know why? It's because unlike going to a bar, which you can do voluntarily, or unlike going to a restaurant, which you can do voluntarily, you're mandated to be here. So the feeling is that we don't want to put you at risk when you're mandated to be here, but we have to figure out a safe way to go forward with the trial. And this is the way that we're going to try to do it. Thomas Jefferson once said that he considered trial by jury as the only anchor yet imagined by man which would be held to the principles of its constitution. John Adams once said that he considered jury service as the heart and lungs of liberty. So in recognition, and I miss doing this because I used to try cases every week, I begin every one of my jury trials with the Pledge of Allegiance. You can see an American flag behind me. If you guys can all turn to the American flag, put your hand over your chest, and we're all going to do the Pledge of Allegiance. If you wouldn't mind unmuting while we do that, okay? I pledge allegiance to the
United States of America, to the republic which stands a nation under God, indivisible, with liberty and justice for all.
Okay, that sounded really strange on Zoom, but I appreciate you guys doing it. Let me start off by kind of talking to you a little bit about this case. The case is cause number DC 1714566. The name of the case is Hector Escobar versus Minwara Ansar. Did we just lose somebody? Did we lose any jurors?
Check,
Julian,
Judge.
what?
I will check real quick to
If
see
you
if.
could check, make sure we didn't lose any. Mr. Maldonado, if you can go ahead and introduce yourself and your client.
Good morning, ladies and gentlemen. My name is David Maldonado, and I represent the plaintiff in this case, Hector Escobar.
And I believe Mr. Escobar is here. Mr. Escobar, if you could go ahead and speak up.
I'm here.
Okay. And Mr. Archibald, if you could go ahead and introduce yourself and your client.
Yes, Your Honor. Good morning, everybody. My name is Chad Archibald, and I represent the defendant in this case, Minawara Ansar.
And there's an Adam Abdul. Is he involved in this case? Does anyone know who he is? He just came in again. Is he with y'all's office? He's not a juror. Okay. All right. Well, let me kind of talk to you a little bit. So first off, one of the most important things is while you're involved in this trial, understand that there's going to be people across the state of Texas watching this trial. This is an historic trial. We ask you, and this is extremely important, that you pay attention at all times. So as long as you're in jury service, we ask you to keep your video on, pay attention to what's going on, make sure that, for example, one of the other trials that was tried before us, one of the jurors decided, you know what, I'm going to take a break, even though we're in the middle of trial, and I'm going to go to the restroom and I'll come back 5 minutes later. And guess what everyone talked about when it came to that trial? The fact that one juror went to the restroom. So understand that we want to make this as comfortable as possible for you, but consider yourself in a courtroom. Consider that you are in the, I know it's hard to, you can see in my background, it's I'm actually in the courtroom, that you're in a courtroom. So if you were in a courtroom, you wouldn't just stand up and walk out. You would say, Judge, hey, I need to take a break, and we'd be glad to let you take a break. Does that make sense to everyone?
Yes.
Okay.
Yes.
Great. Please don't, while you're, as long as you're in jury service, do not communicate with anyone through any type of electronic device. Don't be texting people. Don't be emailing people. Don't be doing other work. Be focused totally on this jury service. Now, let me kind of talk to you about some of the rules here today, because they're very, very important. Understand that just because this is a virtual trial doesn't mean that the same rules don't apply. The Texas Supreme Court has adopted rules for virtual trials, and they'd say that we're going to conduct them as close as possible to a actual in-person jury trial. And so these are some of the rules that you need to follow. First off, although this is virtual, you may see other people here that you know. For example, you might know Mr. Maldonado, or you might know Mr. Archibald. And I actually should ask that. Does anyone here know Mr. Archibald or Mr. Maldonado? Anyone here?
Your Honor,
Nobody?
I have I've had depositions with Mr. Maldonado before, Your Honor.
And
Juror number 42.
Number 42, you know Mr. Maldonado?
Yes, Your Honor, I've had cases with him before.
What do you do for a living, Mr. Stone?
I'm a civil defense attorney.
Are you Miss Christina Stone's husband?
Yes, Your Honor.
Okay, so I have met you before.
Yes.
You said you're a civil defense attorney? Is that what you said?
Yes.
And what firm are you with?
Stewart Law Group with Amy Stewart.
Okay. Right. Does anyone else here know Mr. Maldonado or Mr. Archibald or their clients? Okay. Great. Second, I don't think this will happen over Zoom, but don't accept any favors from any of the attorneys or any of the parties, however slight. Third, this is the hardest part, and this is going to be, I always go into quite a bit of detail when I have the jury here live, and it's even more important here virtually. You're not allowed to talk to anyone about this case, either in person, over email, over chat, over social media, anyway, until you're released as a juror in this case. Now, I have good news for you. Civil cases can be very, very long. Sometimes they're as much, I've had 6-7 week-long trials, but this case is going to be very short. We're going to finish this case by tomorrow. And so that's the good news. But it's very important during trial that you not talk to anyone about the case. I will tell you that I've been giving this instruction for the last 14 years. This is my 14th year as a judge. And I didn't realize how difficult it was until my wife served on a jury for a week and a half and we couldn't talk about it. It's very difficult. And you're probably thinking, and I believe this is 100% true, you're participating in something that is really historic and really special. And you're going to probably want to talk to your friends and family like, hey, I can't believe this. I'm in the middle of the very first virtual trial in Dallas County and only the third in the state of Texas. It's something that'll be great for you to talk about, but you can't talk about it until you're released as a juror. Does everyone understand that, guys? Give me a big thumbs up like this if you understand. Great, great. Okay. Now, the other thing that's really important, how many people, give me a thumbs up if you're on Facebook? Anybody on Facebook? Anybody here on Instagram? How about LinkedIn? How about MySpace? Anybody? It's usually like one juror, okay. One of the other things that's really important is that you not post anything about this. This is going to be really, I think, interesting, the case that you're going to hear, but also the process that we're going through. You might want to post on Instagram or Facebook or LinkedIn, hey, everybody, I'm in the middle of a jury trial right now. It's really great, and let me tell you about it. But let me tell you, that could cause us to undermine everything that we've done to try to put this trial together. You're allowed to post whatever you want after the trial is, after you're released as a juror, but as long as you're a juror, you can't communicate with anyone. And the reason for that is it wouldn't be fair to the parties if somebody heard about it or were influenced by that. Could everyone follow that instruction? Give me a thumbs up if you can follow that instruction. Okay. Juror 50, are you okay? All right, perfect. All right. Now, let me tell you what we're going to be doing. The first part of this trial is going to be jury selection. We call it in Texas voir dire. The proper way to say it is probably voir dire, but in Texas we say voir dire, and that means to speak the truth. And what we're trying to find out is about whether or not you have any biases or prejudices about this particular case. Now, let me tell you this. This is really important. I have jurors all the time say, Judge, I'm not a biased or prejudiced person. That's a bad thing to be. And I absolutely 100% agree with you, but it has a very particular meaning when it comes to lawsuits. And I'll give you an example from my own personal life. A few years ago, I bought a car. It was the very first time I'd ever bought a new car. I was very excited about it. I drove it off the lot. And for the first 6 or 7 months, it ran really well, but then it broke down. And I thought, I have somebody named, I'm joining. You know who that is?
I'll find out, Judge.
Can you find out, Judge Purdy? Okay. I drove it off the lot. 6 months later, it broke down. Thought that was kind of weird, but I took it back to the dealership. They fixed it. 3 months later, it broke down again. Took it back to the dealership. 3 months later, it broke down again. Then it broke down again. Then it broke down again. And I told my wife, honey, this car is a lemon. I'm going to take it back to the dealership, see if I can return it. And guess what happened as I was driving back to the dealership? What do you think happened, guys?
It broke down.
It broke down again. Exactly right. So if this was about whether or not that car company made reliable cars, would I be a good juror? No.
No.
I wouldn't be a good juror because I have too much of my background about that particular car company. There may be things in your background that may not make you the best possible juror for this particular case. So please remember, I believe Ricardo gave you the oath. Did he give you the oath in the jury room?
No.
Oh, did you not get the oath?
No.
No.
Oh, you haven't got the oath. Okay. Great. You were supposed to get the oath. Rhonda, can you call Ricardo and ask him to come back in here to give them the oath? I think we got a little bit excited and we want to make sure they have the oath before we get started. Rhonda, can you do that for me real quick? But you're about to do an oath, and one of the oaths the oath is going to say is that you have to tell the truth whenever the attorneys are asking you questions. So if you don't tell the truth or you don't share something that's responsive to the attorney's questions, then you're violating your oath. So once we get Ricardo back on, we'll go ahead and do that. Before we do that, I do want to ask you guys a question. And this is an important question, 2 questions actually. I think I know the answer to one of them, but this case is going to be a short case. We're not going to be here until next week. We're not even going to be here till Friday. I think we're going to finish this case pretty easily by tomorrow. But does anyone feel that they would suffer an extreme hardship by serving on a jury of that length? Now, understand I can't consider work-related reasons, as you can imagine. Otherwise, the legislature has said that we're not allowed to do that. And Judge Purdy, could you also call down to Ricardo and see if he could join us to do the oath?
Yes,
And did we figure out who iPhone was?
they've dropped off.
Okay. Okay, so anyone here feel that they would suffer an extreme hardship by serving on a jury of that length?
No.
Anybody? Go ahead and do a raise hand if you feel you would suffer an extreme hardship. I do know that somebody has an issue tomorrow that we'll talk to them about. But other than that, anybody else having a hardship?
Judge, I already expressed my concern about that.
Yes, we'll talk about that, and I'll tell the attorneys about that when we take our break.
Thank you.
Anybody else have a hardship they want to talk to us about? Okay. All righty. Let me do this. I'm going to try to do the oath myself. I haven't done it in a while. So I'm going to ask you guys to all raise your hand. Do you swear or affirm that you will give true answers to questions posed to you by the attorneys in this case about the matters in this case to the best of your ability?
Yes.
Yes.
All right. Thank you so much. All right. So, Mr. Maldonado, let me kind of give you a brief overview about what's going to happen now. Mr. Maldonado is going to ask you a series of questions. Each side will have 30 minutes for questions. What we'd like to be able to do, if possible, is let each attorneys ask their questions, and then we will take a break. But if anyone needs to take a break before that, please let us know. And also realize that this is our first time of doing this. I apologize if this gets to be a little bit rough or is not as smooth as we'd like, but we're going to do our very best to try to make this as smooth as possible. So if you notice that you've responded and the attorney hasn't seen you or whatever, please let me know, and please feel free to speak up. Does anyone have any questions before we get started? Ms. Irving, did you have a question? You need to unmute, ma'am. You need to unmute, Ms. Irving, number 19. You need to unmute. You need to unmute.
Okay, can you hear me?
Yes, we can, Ms. Irving.
I don't know what my jury number is. I'm sorry.
You're juror number 19.
Okay, thank you.
Thank you so much, Ms. Irving. Anybody else?
Judge Hoffman, this is Judge Purdy. We have Mrs. Ansar that has joined. I don't believe she's a juror, so we may want to address her.
She is the defendant. Ms. Ansar, if you could go ahead and say hello to everyone. All right, well, you guys will get a chance to see her soon. So let's go ahead and start jury service. All right, go ahead and jury selection. Mr. Maldonado, you have 30 minutes.
Thank you, Your Honor. Please, court, counsel. Good morning, everyone.
Good morning.
Can everyone hear me okay?
Yes.
Yes.
So I have some information about y'all, so I feel it's only fair you know a little bit about me. So again, my name is David Maldonado. I was born in Houston, Texas, but before anyone holds that against me, I grew up in Corpus Christi, Texas. I went to college in Austin, and then in 2009, I came up to Fort Worth for law school, and I've lived in the DFW area ever since then. So as Judge said, what this process right now is called it's voir dire. And the purpose of voir dire, as Judge said, is to identify if any of y'all have any bias or prejudice that might not make you the best type of juror to sit and hear this kind of case. And Judge gave us a pretty good example. Did everyone understand the Judge's example of the kind of bias and prejudice we're trying to identify?
Yes.
Yes.
Okay, good. And so also, as Judge said, this is the first time in Dallas County that we've had a trial completely virtual. And so obviously this is my first time doing this and defense attorney's first time doing this. So there might be some technical issues or some kind of hiccups that might arise during this trial since it's everyone's first time. But can y'all promise not to hold that against my client? I mean, we're trying our best and we're going to try to get through this as efficiently and effectively as possible. Okay? Thank you. And so as Judge said, this is a civil case, so it's not a criminal case. You're not going to have to decide how to punish someone, or no one's going to jail at the end of this. So it's not that kind of case. But I do want to tell you it is a very important case still, and it's very important for Mr. Escobar. He's been waiting since 2017 to have his day in court, or to have his trial. And so it's a very important day for him. And so I just want to make sure everyone understands that. Okay. The first thing I guess I want to ask everyone is, does everyone feel like you can hold someone responsible for their actions?
Yes. Yes.
Yes.
Just by a show of hands, is there anyone who feels like they can't hold someone responsible for their actions? Okay, good. And I know no one's perfect, and you're not going to have to, or you're not going to be asked to judge if anyone was perfect or acted perfectly today. But if you are one of the 12 who's selected to sit and hear this case, you will be asked to determine if someone acted negligently. And what that means is negligence is the failure to use ordinary care, or failing to do that which a person of ordinary prudence would have done under the same or similar circumstances. Does that make sense to everyone?
Yes.
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 Is there anyone who feels like they can't determine if someone acted negligently?
No.
No.
Okay.
No.
Good. And just by a show of, I guess, the thumbs up, is there anyone here who thinks that sometimes car accidents just happen, or accidents just happen? Okay. Mr. Roland, you mind unmuting yourself, please, sir?
Yes.
Okay, so you gave a thumbs up that sometimes accidents just happen?
Yes.
Okay, can you give me an example, please?
Oh, well, somebody just didn't see somebody coming. Just two people get together, and neither one of them saw the other one. That's how an accident can happen, depending on what kind of accident you're talking about.
Yeah, like a car accident. So like
Car accident. Yeah. Yeah.
Okay, can you be a little more specific? Like you didn't see someone coming, like?
You put me on the spot here.
Sorry.
So specifically, if you just didn't see somebody coming into an intersection or something, I don't know. I mean.
Okay, so let's imagine there's a four-way stop sign intersection.
Yeah.
And then say you start proceeding through the intersection, someone comes and you don't see them in front of you and you end up hitting them, something like that?
Yeah, that would be an accident. I mean, if they didn't see you.
Okay. And I understand maybe, you didn't do it on purpose, but in that situation, wouldn't it stand to reason that probably someone ran the stop sign and that's why?
Yeah, if it's a four-way stop sign, yes.
Okay. So in that situation, would it be not necessarily that an accident just happened, but someone acted negligently in running the stop sign and caused that accident?
Yes.
Okay. Can anyone else think of an example where accidents just happened, or an accident just happened?
I've been in several accidents. Some I feel like was out of negligence, and some where I felt like it was just an accident.
Okay. And can you give me an example of one that was just an accident?
The one I felt was just an accident. Someone had bagged into me, but they didn't know that I was behind them, because they was in like a big Escalade type truck, and I have a little Toyota, so he really didn't see me. So when he bagged in, he was trying to not run the red light, so he bagged back into me, but he didn't see me.
Okay, so you were stopped behind him at a light and he backed up into you?
Yes.
Okay.
I didn't take it as negligence. I felt like he genuinely didn't see me.
Okay. Do you think that a reasonable and prudent driver in that situation should have seen what was behind them before they started reversing?
Taking the account of how big the truck was, I felt like to be honest, I didn't even get his information or anything, because I really felt like he I didn't really have damage to my car. He, he kept apologizing, saying he was sorry and he didn't see me. And I genuinely felt that he didn't see me.
Okay. Can anyone else think of an example of accident just happening?
I think number 46 is raising her hand.
Okay.
Weather conditions make the roads slippery or something like that, and they're following, they're not following too closely, and there's ice on the road or something like that, then that could be a total accident.
Okay. So yeah, weather conditions, or
Yeah.
another example that sometimes jurors bring up is if, say you have like some kind of medical condition, like if I'm driving and I have a heart attack and I pass out and then I rear end someone. Obviously, I didn't do anything negligent to cause that accident, right? Okay. So is it fair to say that sometimes there are situations where accidents just happen, like weather conditions or, medical emergencies, but for the most part, there's usually a reason why an accident happens? And usually that reason is someone acted negligently, right?
Yes. Yeah. Yes.
Let's see. Pick on someone new. Ms. Torres, juror number 4.
Yes.
So I'm gonna give you an example. Let's say you come to a stop at a red light, okay? And let's say I'm driving behind you, and let's say I'm texting on my phone, and I then reach over to kind of change my radio station, and I drop my phone, so I reach down to grab my phone off the floor, and then when I look up, I notice your vehicle stopped in front of me, and then I rear end you. Did I do something negligent to cause that accident?
Yes, you weren't paying attention to
Does everyone agree
your
with that?
surroundings.
Yes.
Yes. Yes.
Let's say after that accident, I get out of the car and I go up to you and I say, I'm sorry, I just hit you, but hey, sometimes accidents just happen. How would that make you feel?
Not so good.
Like you don't care.
Yeah, I agree.
And let's say that as a result of that accident, unfortunately, you suffered painful injuries. And so you had to take time out of your day, not only to deal with the pain from those injuries, but also to go get medical treatment. Do you think I should be responsible for paying for your medical bills?
Yes. Yes.
Yes.
Okay. Does anyone think I shouldn't be responsible for paying for her medical bills in that situation?
Juror number 29. If there was some circumstances that, for example, the person who was stopped in front of the vehicle that was rear-ended, you hear about these cases of fraud where people will slam on the brakes and force the person behind them to rear-end them in order to collect, on these kinds of circumstances that you're discussing, then that may be one potential reason that I would say, no, that's not a reason that person should be compensated.
Okay.
But in absence of any kind of fraud and things like that, then yeah, I agree.
Okay. So let's just imagine the situation I described where I rear-ended her because I was trying to grab my phone off the floor. She was already stopped long before I hit her. So in that situation, do you feel like I should be responsible for her medical bills?
Yes. If you're stopped long before, then yeah, absolutely.
Okay. Thank you, sir. And just on a side note, is there anyone who has ever gone and gotten medical treatment? Maybe got, checked out by the doctor, maybe they did some tests and prescribed a course of treatment. And then you get the bill later and you look at the bill and think, man, that's just too low. Has anyone ever been able to go and kind of pick and choose their medical treatment like they're picking off the McDonald's dollar menu and pick your treatment solely based off of price?
No.
Or is it usually a situation you go, you tell the doctor what's wrong, they examine you, maybe run some tests, and then prescribe a course of treatment, and then they send you the bill? And it's usually a little higher than we like. Right?
Okay.
I also have noticed in doing this that there's kind of 2 types of people when it comes to medical treatment. There's what I call runners, who are people who, like, as soon as they get like any kind of, like, say, cold symptom or any kind of injury, they immediately run and go get it checked out at the doctor. And then there's what I call waiters, and those are people who kind of, maybe if you're feeling sick or if you injure some part of your body, you kind of wait to see if it'll go away on its own for, a few days or a week or so before you go and get medical treatment. Does everyone understand those 2 examples?
Yes.
Yes. Yes.
Who here thinks that they're a runner, would immediately go get medical treatment? See a few hands. So I'm assuming everyone else would consider themselves a waiter.
It depends on what I'm waiting for, like what the
Yeah, that's true
situation.
too.
Okay, that's a great
Yeah,
great
it would
point.
depend.
Ms. Likes,
I mean, if it's a,
elaborate on that a little bit.
if I get injured at work, I'm required within 24 hours to report that. So I can't wait. It just depends on what's going on and what the situation is.
Okay, and was that Ms. Carson? Okay, so situation like that. Well, let's say you just had a cold or some cold symptoms. Would you immediately run and get that checked out, or would you kind of wait to see if it went away on its own first?
Well, right now I'm a teacher. I have to go immediately get that checked out because I'm expected to be with students every day and I need to make sure I don't have COVID.
Yes, ma'am. My fiance is a teacher as well, so she's kind of in that same boat, and it's kind of,
I don't have the pleasure to wait. I have to go get it checked out.
yes, ma'am. Is there anyone else who would consider themselves a runner?
Your Honor, I'm going to object to pre-testing the jury.
I think this is okay. I'll overrule it.
Can you repeat the question?
Yes, ma'am. Is there anyone else who considers themselves a runner, would immediately run to the doctor and get either an injury or an illness checked out?
Depends on the situation.
Yeah, it
The
depends.
severity of the accident. Yeah, it would depend.
Ms. Likes,
Yes.
can you elaborate on that? Like what, it depends on the situation?
Well, it depends on what the situation in terms of the injury or the health concern. So maybe I have a pre-existing condition that I know could flare back up or whatnot. So I would be a runner. Maybe a cold in my world, and I know my body, I get a cold, like I'm gonna not necessarily go. So I think it just depends on that health concern for me.
Okay, that makes sense. Does everyone agree with that?
Yes.
So there's certain situations, like obviously if I had a broken arm and a bone was sticking out of my skin, obviously I'd immediately run and get that checked out. But if it's just, maybe some soreness in my arm, I might kind of wait to see if that goes away on its own. And then when it doesn't, I might go get it checked out. Okay. And then in your jury questionnaires, looks like a good number of you have previously treated with the chiropractor. Is that correct?
Yes.
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 Of those people who have treated with the chiropractor, is there anyone who had a negative experience with their chiropractic treatment?
And guys, just so it's clear, because my court reporter is Tony, if you want to say hi to everyone, she has to be able to take down what everyone is saying. And so this particular question in particular, we need to make sure we take it down. So if you respond to a question, can you say your juror number and then whatever your response is? Okay. Go ahead, Mr. Maldonado. I apologize.
It's okay. Thank you, Your Honor. Is there anyone who was treated with the chiropractor and had a negative experience with the chiropractic treatment? I think I saw a hand raised.
Juror 44.
Yes, ma'am.
I didn't really have a bad experience. The only thing that I didn't like about the chiropractor was that they couldn't prescribe a muscle relaxer because they're not doctors. But that would be the only thing that I would have to say if it's negative.
Okay, so nothing specifically with the chiropractic treatment, just that they couldn't prescribe you medication.
Right.
Okay. Is there anyone else who had negative experience with the chiropractic treatment? Okay. And there were also a handful of y'all who said that you would not consider treating with the chiropractor. Can someone?
Yeah, juror number 5.
Yes, ma'am. And why wouldn't you consider treating with the chiropractor?
Just have never thought of that as a way of I don't even know what you want to call it. I don't know if it's I don't believe in it or I just don't know enough about it, but I've never considered it, wouldn't consider it.
Okay, so no specific reason or experience why you wouldn't consider chiropractic treatment?
I think it's just, I don't know enough about it. I don't have, I've, gone to, general practitioners or whatnot, and they've always, been able to help whatever I needed. And that's just never been something that's offered nor something I've considered.
Okay. And let's say you're one of the 12 people who's selected to sit and hear this case. And let's say that you're presented with records of chiropractic treatment and chiropractic bills. Would you be able to look over those bills objectively and make a determination based solely on the evidence you're presented? Or is your mind kind of already made up about chiropractic treatment and you won't consider it?
I would think I'd be able to look at it objectively. Facts are facts. So.
Okay, thank you, ma'am. And I think juror number 9, Miss Stacy.
Yes.
Did you say you also would not consider treating with the chiropractor?
No, I would not.
Okay.
I would more want to get to the root of the problem than treatment of it. So I would expect something like MRIs or something like that, and medication and all, then adjustments and things like that.
Okay. And have you ever treated with the chiropractor before?
No, I have not. I have family members that have, but I have not.
Okay. And did your family members have positive or negative experiences with the chiropractic treatment?
I wouldn't say positive or negative, just kind of benign. They just kept going, and whether it worked, maybe it did, maybe it was just time, or, but they usually did it in conjunction with a doctor.
Okay. And so kind of same question I asked Ms. Likes. If you were one of the 12 selected to sit and hear this case and you were presented records of chiropractic treatment and chiropractic bills, would you be able to objectively look at that treatment and make a determination of its necessity based solely on the records and the evidence? Or are you saying your mind's kind of already made up about chiropractic treatment?
No, my mind's not made up. It's just not something I would do.
Okay. I'll kind of just throw this question out to anyone. Is there anyone who wouldn't be able to objectively look at chiropractic records or chiropractic treatment because their mind's already made up that they would not consider any chiropractic treatment?
I would not, juror 29, I would not consider chiropractors treatment simply based on the fact that, I've heard of a lot of stories where people go in to get adjustments and they end up with things like strokes or other sort of bodily harm that may have been avoided. Like another juror mentioned, had they gone and gotten the appropriate testing and treatment done rather than, I don't want to use the word settling, but going for things like adjustments or glorified massages to try to treat the problem.
Okay. So despite what the evidence of the records would show, your mind's already made up about chiropractic treatment and you wouldn't consider any chiropractic records?
No, I would consider the records, but me personally, I would not seek treatment for that reason. But I do think I'd be able to objectively look at the records and make a decision based on that.
Okay. Thank you, sir. Is there anyone who would not be able to objectively look at the records? Yes, ma'am. Number 32.
So I actually work in healthcare and I work with various different orthopedic physicians and chiropractors. And I actually consult with parents on usually a daily basis on whether or not what type of avenue to go towards, whether chiropractic needs are something that would be beneficial for their athlete or whether they really should pursue orthopedic physician's need direction. And I've seen a lot of, and I do have chiropractors that I trust, just like I have orthopedic physicians that I trust to work with my athletes. But then I've also seen a lot of chiropractors who tend to run the bill up and prescribe dozens and dozens of treatments where I just don't really think that is necessary. I mean, I don't feel like it is necessary. Like, why are you prescribing somebody to come in and just get ice and electrical stimulation and you're charging them a lot of money for that when we can do that at school for free?
Okay. But it sounds like if you were presented with records and treatment, you'd be able to objectively look at them and determine if it was.
Yeah, Yeah, I would, I mean, hopefully I mean, that's what I try and keep parents from doing every day is keep them from wasting their money.
Okay. Is there anyone else who feels like they wouldn't be able to objectively look at chiropractic records because their mind's already made up?
Juror number 40. It's not that I'm in the same boat as like Stacy. I have family members that have, or juror number 9, I have family members that have used it. But I personally wouldn't use it myself. And I kind of think it's like it's an over glorified or overpriced thing that's you're kind of going for it instead of dealing with the problem. So my mind's kind of made up about it, but as far as looking at it objective, I think I could do that, but I don't know, to be honest.
Okay, thank you, sir. Is there anyone else?
I also too had family members and friends. I'm sorry, juror 10. And I felt like that's just my opinion that especially for my mom, she was going continuously and like they said, the bills keep racking up, but she still to this day cannot raise both of her arms. So I just feel like it's a waste of time.
Okay. But do you feel like you'd be able to objectively look at chiropractic treatment records and make a determination solely based off the records? Or are you saying your mind's already made up about them?
As far as the records, I'm not a doctor or anything, so I don't know if stuff was necessary or not. So I would say no.
Okay. Is there anyone else who feels like they wouldn't be able to objectively look at chiropractic records? Okay. And so in these type of cases, it's a civil case. So the remedy, if someone's determined to be negligent and cause someone else to suffer injuries and receive medical.
Maldonado, you have 5 minutes left.
Okay, thank you, Your Honor. Is to provide what's called damages. And there's 2 different kinds of damages. There's what's called economic damages for things like medical bills, where I can show you a treatment record that has corresponding billing and everything so that you can look at it, hold it's concrete. And then there's what's called non-economic damages. And that's compensation for things like pain or mental anguish, something that I can't really show you on a bill, but something that someone did experience as a result of the injuries they suffered due to someone else's negligence. Does that make sense to everyone? Okay. Is there anyone who feels like they wouldn't be able to award any compensation for those non-economic damages for things like pain or mental anguish? No? So everyone, let me ask it this way. If you were presented with evidence that you found credible that someone suffered pain or mental anguish as a result of injuries they suffered due to someone else's negligence, would everyone feel comfortable awarding some amount of non-economic damages for that?
Yes.
Yeah.
Is there anyone under those circumstances who still would not feel comfortable awarding non-economic damages? Okay. And so finally, I want to go over what's called the burden of proof. And so as Judge said, this is a civil case, so it's not the criminal burden of proof of beyond a reasonable doubt, okay? And that's actually the highest burden of proof that our justice system has, because that's governing over criminal cases. So someone's liberty can be taken from them if they're found guilty of committing a crime, and they could be sent to jail. So that's why the burden of proof is so high in those kind of cases. But in this case, the burden of proof is what's called by preponderance of the evidence. And what that means is the greater weight of the credible evidence presented, or more likely than not. More likely than not did something happen. Does everyone understand that burden of proof? Okay. Is there anyone who feels like they wouldn't be able to apply that burden of proof in a case like this? Okay. Is there anyone who feels like that's too low of a burden of proof, just more likely than not? Okay. So no one's going to make me prove this case beyond a reasonable doubt, right?
Well, it needs to be truth. I mean,
sorry, which juror is that?
26.
Okay, and yes, sir, and you would be the judge of if it's true or not, but it's just it has to be more likely than not true, or more likely than not true. Does that make sense?
I guess that makes sense, but it has to be, I guess proven.
Mr. Maldonado, I think you may have misspoke. You said more likely true than not true. Is that what you meant to say?
Yes, Your Honor, I'm sorry.
It's okay.
And so, yeah, since I represent the plaintiff, we have the burden of proving that, but the burden is only more likely than not. So I don't have to prove it 100% true. It's just more likely than not. Does that make sense?
Yeah.
Okay. And do you feel like you can apply that burden in this case?
Yeah.
Only based on the evidence.
Exactly, based on the evidence. Okay. All right. Well, thank you for your time, ladies and gentlemen.
All right, you guys ready? Are you guys okay if we keep going? Anybody? Okay, great. If anyone has an issue, let me know. Number 12, did you have a question? Oh, you need to unmute.
I need to go to the restroom, sorry.
Okay. I don't want to send you to a breakout room right now. So why don't we do this? If anyone needs to use the restroom, just turn your video on and off and then come back and we'll reconvene in 3 minutes, okay?
Okay.
And Mr. Maldonado, Mr. Archibald, you can take a break.
Thank you, Your Honor.
Okay, guys, let's start signing back on. Let's wait for everyone. Let's go ahead and sign back on. Juror number 4, are you there? I can't see. You there?
Yes.
Okay, good. Juror 5, are you there? Miss Light?
Yes, sorry. Yep.
That's okay. Juror 10, are you there? Great. Juror
51 has her camera off.
Okay, juror 51. There we go.
There he is.
Juror 26, 27, 29. I think all the rest of them are on. Mr. Judge Purdy, I think everyone's on now. Do you see everyone?
Everyone's on.
Perfect. All right, guys, that was fantastic. Thank you so much. We're going to go ahead and start up with the defendant's voir dire. He will also have 30 minutes, and then we'll go ahead and take a break, and we'll go from there. So, Mr. Archibald, you have 30 minutes.
Thank you, Your Honor. May it please the court, counsel, ladies and gentlemen of the jury, good morning.
Morning.
Okay, come on. You're not going to make me be that
Good morning.
guy.
Good
morning.
morning.
Good
morning.
Good morning.
That's the feedback I like to see. I mean, what's not to be excited about? You're on jury duty in Zoom. Like, this is a once in a lifetime chance, maybe. But hey, first time for everything, right?
Hopefully once in a lifetime.
So to kind of piggyback off of what Mr. Maldonado said already, we got an opportunity to get to know you guys a little bit today. So I want you guys to know me just as brief as I can. So first, I'm from Oklahoma City. I was born and raised there, and I went to undergraduate at Oklahoma State. So before we get too far, is anybody going to hold the fact that I'm from Oklahoma against me or my client?
No.
Don't be shy. Don't be shy now.
No. Juror number 40, you said Oklahoma State?
Yes, I did. Yes, I did.
UT.
Oh, hey, listen, at least we can agree on the fact that orange is better than red, I suppose. We've got that. In fact, I believe, Mr. Stone, are you from Oklahoma as well?
Yeah, and I might be a Sooner, so, but I won't hold it against
That's
you.
why I went with the color and not the school. What part of Oklahoma are you from, Mr. Stone? Did I see Edmond?
Yeah, I'm from Edmond.
Nice. I'm from Edmond as well. Where'd you go to high school by chance?
Went to Memorial.
No way. Wow. So yeah, my stepmother, she's a curriculum director for the mathematics program over at Memorial. Well, all of Edmond schools. I went to Deer Creek.
Really?
So I'm kind of Edmond, but yeah, it's a debate back and forth. But anyway, to make everybody else feel a little bit more welcome, I wanted to just touch base on a few issues that Mr. Maldonado touched on already a little bit, but I wanted to hash things out a little bit more. So we talk about this idea of negligence, right? And does anybody know what the difference between fault and negligence is? Actually, Mr. Stone, why don't we stick with you since you're a litigator yourself? Can you tell us the difference between fault and negligence?
Put me on the spot. So negligence is, as Mr. Maldonado said, acting outside of the ordinary care of what a driver of ordinary prudence would do in that circumstance. So it goes above and beyond what average is. You can have faults sometimes where you weren't acting in that negligent capacity. For example, if I'm just trying to think of an example, say you purposely do something, you were at fault for the reaction, but it doesn't necessarily mean that you acted negligently.
Well put. I couldn't have said it better myself. You want to take over from here? I think I know what you're doing, but yeah, he's absolutely right. Absolutely right. So I wanted to focus on the key distinction that negligence focuses on the conduct, right? It's not the result. It's not the fact that an accident happened, but it's the conduct leading up to the accident that led to and caused that accident, right? So we've gone through a couple examples of when somebody would not be negligent, and I believe it was juror number 6, Mr. Roland, is that right? You suggested that if somebody couldn't see somebody coming up to an intersection that it might not be negligent, right? But can you think of a situation where somebody would be negligent in an accident? What are some negligent acts that you can come up with?
I would think if somebody chooses to drink and drive and causes an accident, they would be negligent.
Right. I mean, so how about this? Why don't we start with raise your hand or give the little thumbs up emoji if you think you're a perfect driver. I never get anybody to agree to that one. I don't know. One of these days, maybe. All right. How about this? What if you raise your hand if you think you're a negligent driver? I've never gotten one on that one either. I'm not really that surprised, but that's right. Exactly. So negligence is based on ordinary care, right? The ordinary care that a reasonably prudent person would have exercised in the same or similar circumstances. So what that means is that you guys determine what negligence is or isn't based on your understanding of ordinary care. Does that make sense? Does anybody not follow that? All right, I see no hands, so we'll move on a little bit. So jumping to the next very crucial step, burden of proof. We touched on it briefly with Mr. Maldonado's voir dire, and I wanted to kind of break that down a little bit more. So who knows who carries the burden of proof in a lawsuit? Anybody? How about you, juror number 4, Ms. Torres? Sorry to put you on the spot, but.
No, I don't know.
So who do you think brings the lawsuit? What do you think happens when somebody files a lawsuit in general?
The person affected filed the lawsuit.
Right. So if they're filing it, that means that they're the plaintiff and they carry the burden of proof, right? And Mr. Maldonado aptly put it that they have to prove by a preponderance of the evidence, of the credible evidence, that a fact is more likely true than not, right? Does that make sense to you?
Yeah.
And do you agree with that standard, that the plaintiff is held to that burden?
Somewhat.
What do you mean? I don't mean to pick on you.
No,
I kind of want to know a little bit more.
Like we weren't physically there, so we don't know what's true and what's not. We just go based on what both sides say, but both sides have different stories because one's the impacted one that's trying to get something out of it for compensation, and the other side's maybe doesn't think they were at fault. Probably was just an accident.
I mean, that's certainly a possible situation. But keep in mind, Mr. Stone put it or explained to us earlier that there's a difference between fault and negligence. Do you understand? Did that make sense to you when we were talking about the difference between being at fault? Okay. So based on that, do you think that you would be able to hold the plaintiff to their burden and require them to prove by a preponderance of the credible evidence that this accident is proximately caused by one person?
Yeah.
And with that, the defense does not have a burden in that initial question. So we are not obligated to put on any evidence to disprove what the plaintiffs are obligated to prove. Does that make sense to you?
Yeah.
And would
it's
you
basically whatever they bring to the table that we'll go off of.
Sorry, say that again one more time.
Like it's basically what everybody brings to the table that we'll go off.
Right. So the law states that the plaintiff, since they filed the lawsuit, they have the burden to prove everything. And as it stands on its face, just from the beginning, the defendant does not have an obligation to produce evidence, submit evidence, or offer any evidence unless certain situations come up. So would you require the defendant to put any evidence on in support of her position? Or would you be able to just evaluate the evidence that the plaintiff puts on and make your decision based on that?
I would be able to make a decision, but it would be like better if they could provide their evidence.
I know. In a perfect world, right? A coin has two sides and there are three stories to it, right? Or however the phrase goes. But in this situation, since we're in a lawsuit and we're dealing with trial, I've got to kind of know a little bit more specifically. So would you require that the defendant produce and offer and submit any evidence to support her position, or would you be able to base your decision solely off of what the plaintiff has produced?
I would want the other side of the story too.
Okay,
to make a decision.
And that's a perfect point. So there are no wrong answers in the Voir jury selection process, right? So we just want to get to know you guys and make sure that you would all be a fair and impartial juror to both sides, right? So not only fair to my client, but also fair to Mr. Maldonado's client. And I need to make sure that everybody's able to do that for both sides equally, because that's what the law requires and that's what justice demands. And that's the only reason we can do what we do is if everybody is fair to both sides. Does that make sense?
Yeah.
So does anybody agree with juror number 4 that they would want more than just the evidence that the plaintiff has put on? Would require the defense to produce evidence or tell their side of the story or give their version of the events?
Yeah. Mm-hmm. Yes.
Sorry, who was
like
that?
to hear both sides.
Who was that?
Number 26. Sorry.
26 was that?
Yeah.
You said you would
I would like to
both
hear.
sides?
I guess it wouldn't be required, but it definitely help if we could hear both sides of the story and see if there's evidence.
Right. So even though the law does not specifically state that we would have to, we being the defense does not have an obligation to present any evidence or admit anything at all in addition to what plaintiff's going to produce. Would you then require or ask us to produce anything in addition to what they've already produced. Where'd you go? 26. There you are.
I guess I would ask if, they had anything that, I guess, that could, so to help us determine if one guy's lying or, I really don't know.
That's perfectly fair. That's perfectly fair. So the way the law is constructed, and the judge will give you all of the law, so there's not going to be any questions as to whether or not, I'm telling you what you're supposed to know.
Yeah, let me just say that because that raises a good point. The only law you're going to be hearing in this case, the attorneys both say this is the law, this is the law. The only law you're going to be following in this case is going to be coming from the court and the court's charge. And so one person might say the law, Mr. Stone said something about what the law is. I think Mr. Maldonado did, Mr. Archibald. They're all attorneys. They know something about the law, but the only law that you follow in this case comes from the court and the court's charge. So just be aware of that. Go ahead, Mr. Archibald.
Thank you, Your Honor. And that's going to be true for the entire process, right? So the judge and the court is going to provide all of the law, all of the framework for all of us to make our decisions. But kind of jumping back to that original issue of burden of proof, it's not just whether my client was negligent or any one party was negligent, but the plaintiff has the burden to change that original answer of whether somebody was negligent from a no to a yes. Does that make sense? So they've got to move the ball starting at the goal line, starting at 0 with no evidence being presented today, right where we're sitting today. What do you guys think the answer would be? Is it to the first question, if anybody was negligent in this case? How about you, juror number 10? I'm sorry, Miss Walker?
Yes.
What would your answer be if you were asked right now whether or not any one party was negligent in this case? If you were asked right now and you had to give a decision, yes or no, is anybody negligent based on the evidence you have seen so far?
I'm not good at, I work in the court, I'm a clerk for a civil court. And to be honest, it's kind of hard to distinguish who is right and who is wrong to me. Because sometimes I feel like the defendant is right and they lose. So I just don't think I will be able to distinguish who is telling the truth and who is not.
So I'm really glad you brought that up. And you said you're a clerk for a court. Did I catch that right?
Yes, sir.
What court are you a clerk with?
The protective order court.
Okay. So I'm not sure if we would be dealing with the exact same situations that you're used to every day, but in this situation, since the plaintiff brought the lawsuit, they have to prove that my client was negligent, right? So as we've talked about a little bit already, the only way that you can determine whether somebody is negligent is by a preponderance of the credible evidence. And at this point, you haven't seen any evidence at all. So picture a football field and we're starting at the goal line, right? So that's where the plaintiffs start. They start at 0. They have the burden to move that ball all the way up to the 50-yard line and then past the 50-yard line. More likely true than not true, right? So based on the evidence, we haven't heard any evidence, obviously. So do you think that they've moved that ball at all?
No.
Right. You're exactly right. Right. So they haven't produced the evidence. So at this point, the only question or the only answer you can give to that first question is no. Right?
Yes.
Does anybody have a question about that? How about you, juror number 17, Miss Davis? Is that right?
Yes, it is.
Does that make sense? So at this point right now, would you be able to answer the question as to whether or not my client was negligent based on any evidence at all? If you haven't seen any evidence, what would your answer be if my client was negligent?
I wouldn't be able to give a reasonable answer without any evidence at all, because at this point it's just two people telling us what's going on. So without evidence, I won't be able to make a logical, regular decision without any evidence being presented.
I'm really glad you said it. I'm really glad you put it that way, because it's the burden of proof requires that the plaintiff put on evidence to change the original underlying answer, that until there's evidence to say otherwise, my client is not negligent. Does that make sense? Without
any evidence, there's no way of saying it either way. We're still in the middle, so we can't say if anything is, negligent or not without any evidence being proven or given.
Does anybody else feel like juror number 17, Ms. Davis, that they can't make a decision right now based on no evidence at all?
Well, I think this is juror number 5. I think there's no decision to be made because without any evidence or without the plaintiff sharing, I guess, the burden of proof, then that defendant isn't at fault or negligent, I guess.
Wait,
Go ahead, juror number 9, Miss. Is it Stacy? Yeah, Miss Stacy. Yes.
Okay, so if you two were in the courtroom and you did not have a burden of proof, and we're sitting there and there was no proof given, there is no way then your client would be innocent, right? Because nothing was given. So there would be no suit.
You're absolutely right in the fact that there would be no suit and there would be no way to make a decision. But I don't want to cross ways with the guilt and innocence issue, because the innocence idea is reserved for criminal matters, right? So you're right. Everything else but the word innocence, right? So you're absolutely right. If the plaintiffs have not put on any evidence at all,
right,
that answer to question number 1 is still no. Does that make sense to everybody now? Is that a little bit more clear? And does anybody have an issue with that standard? Does anybody not think that they could just outright say no, that there is no evidence, so I can't make a decision? All right, how about this? Does anybody just automatically, as they not walk through the courtroom doors, but enter the Zoom meeting and just automatically decide that there's an accident, so somebody must be negligent? Anybody? Forgive me, I'm flipping through screens to make sure I cover everybody.
Juror number 2.
Yes, ma'am.
At this point, it's just he said, she said, without the evidence there to discredit one or the other. We're just going based off what each party says.
You're right. And is it Miss Long?
You can go Bowie. It's my maiden name.
Okay, I'll go with Bowie. So Miss Bowie, you're onto something absolutely great here. So say that one more time, just so I make sure I get the words just right, so we can talk about it a little bit.
I said without the evidence there to discredit one or the other, it's just a he said, she said story.
You're right. You're absolutely right. And at this point, that's kind of what we're looking at. But keep in mind that the law requires that the plaintiff meet the burden, right? So they have to put on the evidence. And the law does not require that I put on any evidence in support of or to contradict anything that the plaintiffs have said. Does that make sense?
Yes.
Mm-hmm. So at this point, without any evidence one way or the other, the only option is to say no for negligence, period. Are we all on the same page with that one?
Yes.
Mm-hmm. All right. So there's a next little caveat to that burden of proof, and it's the credible evidence. And that's probably one of the most crucial elements of the burden of proof, is that you have to present credible evidence. Who knows what credible means? Anybody? How about you?
Juror number 39. I'm sorry.
There we go. 39. Is that Mr. Mather?
Yes, Mather.
Ah, nice. 50.
Yeah.
50. What do you think credible means?
Well, when you say credible, I and I'm not an attorney, but I would think what does the law view as credible in my mind, or what's what's allowed in a court, or what's not just hearsay, for example.
So without getting into the specifics of hearsay and the nuances of all of that, credible means believable. The believability of the evidence is kind of how we look at things in our context, in lay terms. So here's a great example I like to use. Let's say I bring in, I come and testify, actually. I testify, I swear an oath to tell the truth, the whole truth, nothing but the truth, that I am 9 feet tall. Now, is that credible? Is that believable? I mean, I know I'm sitting down and I know that you can't see me in person.
We'll be taller than that.
Exactly, right? You don't know, right, Miss Irving? That's absolutely right. Now, Miss Irving, before we get too far, are you from Oklahoma City as well?
I'm Oklahoma City.
405, there we go. What part of Oklahoma City are you from?
I'm from Oklahoma City.
Awesome. I love
From the
it. I
city.
love it. There we go. There we go. So, okay, Miss Irving, I'm going to stick with you a little bit. Since you don't think I'm 9 feet tall for some crazy reason, what if I brought in a government issued ID and it says Chad Archibald, hazel eyes, red hair, 9 feet tall every day of the week? Is that credible?
No, because if you're not 9 feet tall and you have something stating that you are and you're not, it's not the truth.
There you go. There you go. Who else follows that line of thinking and agrees with Miss Irving that no matter how many government issued IDs I bring, I'm still not 9 feet tall? How about you, juror number 20? I see you nodding along and you've been kind of quiet. You've escaped so far, but not much longer.
I would agree. There's
All right.
no...
So how about this one? What if I bring in some medical records, right? So they say Chad Archibald, my date of birth, no question that it is me, but they state 9 feet tall. I'm a doctor. I've written these records. He's definitely 9 feet tall. Is that still credible? Miss is it Brumlow? Am I saying that right?
Brumlow.
Okay.
Yes. I mean, there's what you have on paper and then there's what you have in front of you. So I have to go with what I can see with my own 2 eyes.
There you go. And so would you believe those records if you saw for yourself that, no, there's no way. He's not 9 feet. Guinness Book of World Records would be knocking on his door. He's in the wrong profession if he's 9 feet tall. But so that's not credible, right? And what if we even had a doctor come testify? Juror number 16, I don't know if we've talked to you much yet, so I want to give you an opportunity to share the floor. Do you think it'd be credible if my doctor comes in and has his records in front of him saying I'm 9 feet tall and swears that same oath? Is that believable?
No.
Right. Because at the end of the day, you got to use your common sense, right?
Exactly.
So if the plaintiffs bring evidence that doesn't make any sense on its face and it's not believable, is that credible evidence? No. Does anybody disagree with that? That government issued ID says it, the medical records say he's got to be 9 feet. I don't know. I might need to get my glasses checked, but he's probably 9 feet if that's all of that support's there. Does anybody say that they would believe that I'm 9 feet tall in that situation? All right. Good deal. So that's kind of what we're thinking about today. So the evidence isn't documents. It's not just, pictures and medical records. It's everything.
Sorry, juror number 29, you need to turn your camera back on. Okay, sorry about that.
The evidence is the information, the tangible information, the testimony, the documents that will be produced, the pictures that will be produced. All of that comes together to be the evidence in support of a position, right? Does anybody have any questions about that? Juror number 3, does that make sense that the credible evidence is only the evidence that comes through the witness stand? Mr. Longoria, is that right?
Yeah, that's correct.
So do you have any questions about what credible means? What would you find to be credible evidence?
Credible is pretty much something that you would see and believe, because in the example that you were using, somebody could have made a mistake and put that you were 9 feet tall, but everyone around you is seeing that you're not 9 feet tall. So
perfect. That's exactly right. I'm really glad that hit home with everybody. So let's jump forward a little bit.
5 minutes.
Let's talk about bills specifically, right? So show of hands, if anybody goes to a nice steak dinner for date night and the bill comes and without even looking at it, you just throw your credit card down. Who does that? Be honest. It's okay. All right. Juror number 5. What's Miss Likes? Am I saying that the right way?
Yep.
So lunch is on you today, right, Miss Likes?
Yep.
Okay. And why do you just pay the bill without even looking at it?
Because I know where I'm going. I know the average meal prices. I've looked at the menu. I kind of tallied that up, and so yeah.
Okay. So let's play a hypothetical situation here. If you don't go to somewhere you're familiar with, it's a new restaurant, you haven't seen the prices on the menu. It's one of those fancy ones that they don't put the numbers. That's always the most terrifying situation. Would you then still put your credit card down and say, yeah, take it. I'm full. So here's my payment. Here's my payment.
It depends on who's with me. So if it's my mom, yeah. If it's somebody else, I'm gonna check on it and maybe ask them to split it. But sure,
So
yeah, I'll check it. I'll check it.
So in that situation, what would you do if you got if you ordered the T-bone steak and a salad, but you were charged for a T-bone steak, a salad, a bottle of wine, another bottle of wine, and then another a lobster tail on top of it? What would you do in that situation?
I'd look at the total. It seems off, but then I'd ask for the details.
And would you want to pay for the things that you didn't order?
No.
No. Would anybody pay for the things that they didn't order in that situation?
No.
So who here would ask or question or look at the bill before they pay it?
Juror 2, I would.
I mean, after that lobster tail, I would too. I mean, I've been to Bob's Steakhouse once and had it. It was pretty good, but I'd still want to make sure I was getting it before I was paying for it.
Juror number 38.
Yeah.
Although I agree from my personal perspective, I've worked in healthcare for over 20 years. I can tell you that many folks who get a bill that are members do not know the ins and outs of healthcare. So they may not understand what the codes or the billing, the itemized bill, what they're looking at. So although I agree for my personal self that I would look at a bill, doesn't mean that anybody who receives a healthcare bill would understand what they're looking at and not ever question it.
That's perfectly fair. And now, sorry, what was your last name? It's all cut off, and
Resendez.
Ms. Resendez, what do you do? You said you're in the healthcare profession. What do you do specifically?
Well, I've done a lot of things, but my last it was customer service. So we had a area that was taking calls from our members, and so there was many calls that would come in, and the members did not really understand their EOBs, their explanation of benefits. They really didn't understand their benefits, period. So when they get those types of things, they really don't know. And my brother, who was in the hospital, when he got a bill, he didn't understand it either. So I see both sides. Me personally, yes, I would look at a bill. There are several people in our the healthcare that are members of healthcare that don't understand the dynamics of that.
Okay.
Healthcare is very complex.
And which is why I'm really glad we have juror number 29, Dr. Kalaki. Am I saying that even close?
Yes, sir.
Awesome. So Dr. Kalaki, I understand you're a surgeon, is that right?
Yes, sir.
And now you mentioned earlier that you don't like chiropractors, and you gave a couple examples. Can you tell us a little bit more why you don't like chiropractic care?
So it's based on anecdotal evidence, just case reports and other people talking about really terrible outcomes that happen at a chiropractor's office. And part of that, in my opinion, comes from inadequate training. And like I mentioned, sometimes jumping to some sort of interventions that aren't based on any sort of workup. Like if you go to an orthopedic surgeon with back pain, you may get some x-rays, you may get an MRI, you get a really good physical exam. If you go to, let's say, a chiropractor, and this is all obviously generalizing, if you go to a chiropractor with back pain, you may start getting some sort of, like massage therapies or other sort of interventions that aren't necessarily proven to be effective. And in my opinion, that's not right.
Okay.
You have 1 minute.
And Dr. Roberts, I believe you're a surgeon as well. Is that right?
That's correct.
And what's your opinion on chiropractors as a medical professional yourself? Well,
my father's a chiropractor.
I'm sorry, say that again.
I said my father is a chiropractor, so I'm a little bit biased in that way. But
I'm glad you mentioned that. I'm glad.
I've seen both sides of that coin. In fact, my dad has pointed out some other chiropractors having some shady business practices. So I think that there's good and bad out there, just like there's good and bad medical doctors.
And what did your dad say specifically about the shady chiropractor practices?
There are different business structures such that, they'll get them on a regiment where they have multiple treatments in a week rather than reassessing at every appointment, how they're doing, how they're progressing, maybe backing off. They'll just continually schedule multiple times in a week. And it does kind of run up the bill.
Thank you, Mr. Archibald. Your time is up. We have to be fair to both sides and give an equal amount to both sides. So you have 30 minutes, just like Mr. Maldonado did. So let me kind of explain what's going to happen next. We're going to put you guys into a breakout room. We're going to go back in and probably bring some of you back into the jury room to ask you some additional questions. But you will have at least 5 minutes between now and when we start bringing in individual jurors. Once we've gone through the process of talking to individual jurors, it'll probably be another 20 or 30 minutes before we actually have a jury. So what basically is going to happen, you're going to have about a 5-minute break. Just wait in the jury room. Once you're done with that break, we'll bring some of you out individually, and then the attorneys are going to have some time to make a determination of who's going to be on the jury, and then we'll go ahead and seat you. Does anyone have any questions about what's about to happen? Any questions, guys? Okay, so please do not sign off. Please, please, please do not sign off. What, someone said something? I'm sorry. Okay, please don't sign off. I'll stay on Zoom, and we're going to send you to the jury room. You can take a quick break, and then we'll bring back some of you individually. So I'm about to send you guys all invitations. So give me 1 second. This will take just 1 second. And I just want to commend all of you. You guys did a great job of paying attention. I know it's hard to do that on Zoom. Judge Purdy and I were both, oh no, what just happened?
Juror number 47's camera needs to be on.
And juror number 47, something just happened. Uh-oh. I apologize. Let me recreate. Let me try again. All right, something happened. I apologize. You should get an invite in the next 30 seconds or so, and just accept the invite to go to the jury room. Why did it do that?
It's at 25.
Okay, but what do I do?
No, just scroll back up and click 25.
Okay.
Just keep assigning.
Okay. I don't want to assign. I'm going to send you as well.
I could have just gone on my own.
Okay.
Judge, do you need me to contact juror number 47?
Juror 47, are you there? They may have already taken a break. Yeah, we'll go ahead and try to contact them.
Okay.
And I'm going to send the bailiff as well. I'm going to send Mr. Tagnon, who's behind me. He's an intern from SMU Law School. He's very tech savvy, so he's going to go with you. We're going to open it, and then we'll bring you back individually, okay? We have a 5-minute break, but stay on Zoom. You should be getting invitations right now. All right, Sheriff, I hope Nancy told you what to do, so. Okay, you joined, perfect.
You've reached Bryce. Leave your message at the tone.
Okay, juror 34, did I not assign you? You need to go to, let me see what happened. Juror 34, did you get an invitation? Juror 34.
I think 34 is me, yes.
I sent you an invitation, ma'am, number 34. You need to accept the invitation.
Okay, join. I push join, yeah.
Will they not automatically go? Okay, juror 15 already took a break. I'm going to stop the live stream, this portion of the jury selection. Juror 15, I'm so sorry. You need to join the jury room.
You should have received an invite. Oh, she went.
She went, okay. But I'm going to stop the live stream now because this would be a private portion of this where we're going to talk to the attorneys. I want to make sure that nobody watches the YouTube stream. So for this confidential portion. So